Morning, everyone. I'm Brant Beaudry. I'm super excited you're all here. I'm going to give people about two, 3 more minutes as people are filtering in to find their seats. So be on in about 2, 3 minutes. How long do you think you'll live? That's good. I had a client ask me that the other day. I was like, well, I hope another day, but I don't know. We don't know. So what we want to do is we want to plan. That's what we're here talking about today is estate planning. My name's Brant Beaudry. I'm a local attorney here right across the road from Harvest Foods. I'm also a trustee of the Northwest Montana Estate Planning Council. We do a lot of estate planning at our office, and today I'm going to talk to you about the ins and outs of estate planning. But I want to let everyone know the scope of this presentation is limited to people with less than $30 million, okay? Once we hit that mark, we're at federal estate tax planning, and that's actually sort of a whole different level of planning. And so anyone with over 30 million, please leave, don't come back. Today, please feel free to take notes, ask questions, be interactive. The last time we did one of these, I got some feedback that a lot of people really appreciated getting to hear the questions of those around them and then the answers to that as well. I will also have Vanna White be bringing a mic over to each of you. Actually, it's going to be Dorothy. I get them mixed up sometimes. So Dorothy will bring a mic. If someone has a question, just please raise your hands, and Dorothy will bring the mic over to you. Here's our agenda for today. We're going to talk about an introduction to estate planning. We're going to visit about probate, which I call the P word. We're going to talk about last wills and testaments, trusts, automatic transfers, which I call the heroes, power of attorney documents, tax consequences, guardianship and conservatorship, and we will have a question and answer sheet as well, or question and answer time as well, but feel free to stop me at any point and raise your hand, and Dorothy will bring a mic over to you. So why do we do estate planning? To me, it really boils down to two things: avoiding probate and making clear transfers to our heirs. That's about it. There's a few other reasons though. We want to avoid family fights, right? That starts with clear transfers. And we want to potentially plan for incapacity. So if you don't really know what you're doing and you're incapacitated, we want to plan that someone has your best interest in mind and is able to step up for you. And that's when we're going to talk about power of attorney documents today. I also want to talk about estate planning myths today. And I want to debunk some of those myths with you guys. before we even get started. The first one is wills trigger probate. Okay, and I know I'm ruffling some feathers because I've watched several social media videos where people say, don't get a will, wills trigger probate, don't get a will. And I have many clients that'll come in and say, hey, my cousin told me that wills trigger probate. So what's the deal? Why are you setting me up with a will? Okay, that's a myth. Myth number one. So non-planned for probate assets trigger probate. Wills don't trigger probate, and we're going to go over all those today. The second myth is that wills avoid probate. They don't. You need to plan for your probate assets to avoid probate. The will is the backup teammate that makes sure that if your automatic assets aren't planned for, that someone's in charge and that it's a clean transfer to your heirs. We will go into depth with the automatic transfers today. The third one is that trusts avoid probate. Who here has heard that trusts are the greatest thing since sliced bread? You hear about it all the time, online especially. You hear, trust saved my dog's life. Seriously, they're just the best thing, and people need a trust. And in Montana, that's not always the case, okay? Trusts don't necessarily avoid probate. They can be a tool to help, but making sure that all of your probate assets are planned for is the way to avoid probate. So remember, probate assets that are not planned for are what trigger probate. We'll have a long discussion about probate here today as well. Trusts are better than wills. That's the next myth. They are not. They are more expensive. They're a little bit more complex, but they're not better. Everyone's estate plan is going to be a little bit different based on their circumstances. And so we're going to talk about when someone would be recommended with a will versus a trust today. Everything goes to the state. If you don't have an estate plan, everything goes to the state. It's a big worry. That is actually based somewhat in truth that there is a legal term called an escheat estate. It means that if you don't have any heirs or any relatives and you pass away and you don't have a will or a trust, that all of your assets will go to the state. That is true. It's pretty rare. I've only seen it a couple of times, but most people have some distant cousin, aunt, relative, and so that's who would actually end up inheriting their stuff. If they did not have one, then it would go to the state. But a lot of people will just automatically assume if I don't have a will or don't have a trust, everything will go to the state. Not true. Expensive estate planning is the best. I can't tell you how many clients I've had that have had a big book, a big trust, and they've slapped it on my desk and they said, the best estate planning lawyer in California wrote this up. I'm like, okay, how much did it cost? $10,000. What does it say? I have no idea. Expensive estate plans don't mean good estate plans. They just mean you might have gotten something that was complex. And California has a lot more complex estate planning laws than Montana does. Luckily, Montana is the best state for estate planning. Very simple and clean here. But it's incredibly important that you always understand what's in your estate plan, that you can read it. If you can't read your estate plan and it takes another lawyer to read it, I don't particularly think that's good estate planning. Cheap estate planning is the best. So now we're on the other end. Hey, AI wrote my will. I think it's good, so I'm good. AI can be really useful. Google can be useful. People have been doing Rocket Lawyer, templates, all of these things to get quick estate planning documents. And they might be okay and they might be valid, but that's not going to avoid probate, okay? Making sure we plan for our probate assets is how we're going to avoid probate. Young families don't need estate planning. Not true at all. Young families have assets. They may have young kids. And a last will and testament is exactly where you'd put a guardianship and conservatorship provision for your kids, your young kids. My wife and I certainly have one, making sure that the person that we've named would watch after our kids and our assets to make sure that our kids are able to have a planned out life without their parents. Probate is the P word. What is probate? Probate is where a court transfers your assets after you pass away. Real estate, accounts, and vehicles. Okay? And so if they're not planned for, those are the probate assets. So a court will say, yes, that's okay. The executor, the personal representative can transfer those. And having the court involved means you have 10 to 15 legal documents involved. And they're pretty expensive for an attorney to produce. They allow for creditors to attack your estate and say, hey, you owe me money, I want it, your heirs shouldn't get it, I should get it. Probate's not the worst process in the world, especially in Montana, but it can be anywhere from 3 to 10 grand typically is a range that we'd see probates in. But if we can avoid it by just planning for our probate assets, that's the type of estate planning we want to do. What triggers a probate? If you don't remember anything from what we talk about today, I want you to remember that probate can be sticky and icky, like tar. Tar, T-A-R. It is titled vehicles, accounts, and real estate. Titled vehicles, accounts, and real estate. Those are the probate assets. As long as those are set up for automatic transfers, you will avoid probate with your estate. Question, Mr. Dar up front.
Equipment or farm machinery?
There you go, Dorothy. So we got a question up front. It's on.
My question was, what about farm equipment or manufacturing equipment?
So the question on the table is farm equipment, manufacturing equipment a probate asset? It is not. It is not titled, so you don't have a title for it. So it is just tangible personal property, which is not a probate asset. So pets, rings, coins, jewelry, guns, these are not probate assets. You should plan for them and write who you'd like them to go to if they're special, but they won't trigger a probate if you pass away. Thank you for that question. Will the state take my property in probate? If you have any heirs, no. If you have a will, no. If you have a trust, no, they won't. Will lawyers take my property in probate? The lawyers get rich, right? No, but by way of example, I want to talk about California probates. If a probate is triggered in California, let's say you have a second place in California or something like that, the lawyers there on a $1 million probate are required to take a $23,000 probate fee, the lawyers themselves, and not to mention the court costs there. So California probate can get very expensive. Montana typically is an hourly or a small percentage of an estate for a probate. But generally, no, lawyers won't take everything in probate. I like to think of a probate case as almost like someone has blown their transmission in their vehicle, so they bring their car to their mechanic shop, and the mechanic says, I'm really sorry, it's gonna take quite a bit to fix this transmission. It's gonna be $5,000, right? And it's a matter of whether you trust the attorney that that's what it's gonna cost them to handle the probate, open up the documents with the court, or whether you don't and you go next door to the next mechanic or the next attorney. That's sort of the way that I think of probate and fees as far as clients go. How do other states handle probate? Every state's different, actually. Most of the states in in the central northwest United States, North Dakota, Montana, Wyoming, Idaho, pretty similar. Completely different from Washington, Oregon, California. Those are states you absolutely want to do everything you can to avoid probate in. Can I avoid probate? Yes, you can. I thought you'd never ask. We need to plan for our probate assets, all of us. We're going to start it off on our estate planning documents by talking about last wills and testament. This provides for asset distribution, who you want to get what you have. They name an executor, that's someone to take care of everything that you have. They're the one that takes charge, takes the reins. And a lot of people are like, well, I want to name all 4 of my kids as executor of my estate. Then they can all take charge. I can't tell you how many times that's led to siblings hating each other, real big time court disputes, where maybe 1 or 2 of them wants to keep the family home and the other 2 don't, so they have to have court intervention. So please don't name all of your kids as your executor. Probably just name one, the most responsible one, right? You can also name attorneys. You can also name friends or other family members that you trust. Did you have a question? Okay. Your will also names a guardian and conservator of maybe you have a young family and you want to make sure that both sets of grandparents aren't fighting over who gets to watch over your kids, and you've maybe named someone else, and that's okay. The court is going to respect who the parents wanted to be the guardian and conservator of their young kids. Last wills and testament may avoid probate. One thing that's really scary is my friend told me, and I get that all the time, my friend told me that you set me up with a will, now I'm going to have probate. And I saw it on a social media thing too. Not true. Your probate assets, as long as they're planned for, you will not have a probate. And your last will and testament is there as just the backup guy, just to make sure that someone is in charge in case you forgot to plan for one of your probate assets. So last will and testaments are very important, mainly for the reason of putting that person in charge. General cost for a last will and testament is $500 to $1,000, and those always come with power of attorney documents, and we'll get into those in a little bit here. Revocable trusts. Now, these things on social media and on online forums are the hottest thing ever. People really love them, and lawyers love selling them. Lawyers love selling these because they can bill a lot for them. They're generally between $800 and $1,500, and a lot of lawyers love to push these because it's a lot of good time that they can bill. But it's not for everyone. A revocable trust provides for asset distribution, names a trustee, that's someone in charge, just like an executor or personal representative. And it may help avoid probate, but it won't avoid probate unless your probate assets are all planned for. General cost on these is about double the will cost, but $800 to $1,500 depending on complexity. Unfunded trusts are very common. And what I mean by an unfunded trust is that person that I gave the example of having that big trust document and setting it on your desk and saying, hey, I have the best trust ever. I'm not going to have probate. This is great. All of their probate assets need to either be owned by the trust or as a pay-on-death beneficiary of the trust. So their titled vehicles, they all need to be signed or owned by the trust to avoid probate. Their accounts all need to have pay-on-death beneficiary as the trust to avoid probate. And their real estate, every piece that they own, needs to be owned by the trust. So many people will have this big, thick trust, but they and their spouse will own their real estate. The trust doesn't own their real estate. That means that trust is unfunded and not doing anything. Okay, so if you do have a trust, make sure that your real estate is owned by the trust and make sure that your accounts are either owned by the trust or that they are the pay on death beneficiary of the trust. One of the most common reasons probate is triggered is people forget to put their new house or their house that's out of state into their trust. Or they had everything set up great with their estate planning lawyer, and then they moved states and forgot to buy their new house in their trust. Really, really common, but something to pay attention to. Trusts are absolutely essential if you own real estate in California, Oregon, or Washington. Some other states don't have automatic transfers the way that we do for real estate. In Montana, we have what's called a transfer on death beneficiary deed. We'll get into that a little bit more. But in those other states, they may not have transfer on death beneficiary deeds. And so a trust is actually the only way to avoid probate. And so we have had an influx of out-of-staters moving to Montana in recent years. And a lot of them, they came here with their own ideas of what an estate plan needs. And so I'll have a client come in and say, hey, my cousin from California was really upset that I didn't get set up with a trust. What's the deal? I'm like, well, your cousin from California absolutely needs a trust. She owns real estate in California. You don't. We set you up with a transfer on death beneficiary deed, which avoids probate. And she's like, oh, yeah, she hadn't heard of that. And so just be careful with listening to your buddies about estate planning advice, because they're usually half right. Question, Anne.
Yes. How does a revocable trust protect your property from debt collection?
Good question.
Oh. How does a revocable trust protect your property or assets from debt collections?
Good question. How does a revocable trust protect your property from debt collection? I'm going to give you a couple different answers. So let's say you have a revocable trust and your kids are the beneficiaries and they have their own creditors that are trying to attack the trust. Those creditors can't due to a spendthrift provision that would be in the trust. So that's good that it would protect your assets from your kids' creditors. Your creditors can attack a revocable trust. So if you have your own revocable trust, or you and your spouse have a revocable trust, and you have creditors that are trying to go after your money, they can go after your revocable trust. Creditors cannot go after irrevocable trusts, but irrevocable trusts you don't have control over. So basically, if you have control over your asset, creditors can go for it. If you don't have control over it, creditors cannot go for it. One size doesn't fit all. When we're talking about estate planning, we want to know, how many children do you have? Do you have kids from a prior relationship? Maybe we need to plan for stepchildren, and what happens if one of us passes away? I don't want any of my kids to lose their inheritance, that type of thing. Do you own property out of state? As I mentioned, in California, if any of my clients sit down with me and they're like, I own property in San Francisco and Montana, then I immediately say, hey, we're going to be talking about trusts today. We're not going to be talking about wills, because we need to do everything we can to avoid California probate. And so everything should be owned by the trust. Do you have children with ongoing needs, costs, and expenses? That's another reason for a trust. It's a fund that can hold money to distribute money to your kids on an ongoing basis. Sometimes a special needs trust where you might have a child or a loved one with some sort of disability where they're getting state-funded benefits every month, and we need to be able to make sure that they get enough money to stay on state-funded benefits, but that you're still able to help out for their care as much as you can. Automatic transfers. If you forget everything I say today, please just burn this slide into your brain. We talked about probate sometimes being the sticky, icky mess of tar, right? Titled vehicles, accounts, and real estate. These are all of the ones that we want to make sure there are automatic transfers on. And right now, we're going to go over all three of these and how you can avoid probate on all of them. So if there's a secret to this discussion today, it's this slide. Titled vehicles. Up until October of 2025, all titled vehicles needed to be signed and notarized in order to be transferred to another person. The law changed, and now in Montana, all of your titled vehicles can just be signed. They can just be signed. So, they have to be signed exactly as your name is written, though. So, if you forget what I'm saying about titled vehicles, please just call my office and I'll walk it through with you, because this is not something you want to mess up with the DMV. My name is Brant Roman Michael Beaudry. I have 4 names. So if on title it says Brant Roman Michael Beaudry, I need to sign it as Brant Roman Michael Beaudry. Not how I normally sign, but that's how I have to sign if that's on title. But if on title it says Brant Beaudry, I have to sign as Brant Beaudry. By signing your vehicle titles, they avoid probate when you pass away. They can go to your heirs, your spouse, whoever you wanted them to go to automatically without probate. Now, one question I get a lot is, and I think I get a question here, and what was your name? Eileen, right here. Oh, Eileen's got 2 questions.
Okay, hi. So on the titled vehicles, if you sign your title, just put it in your safety deposit box, and it's part of the trust, it will just be dispersed?
Great question. So Eileen asked, if you sign your vehicle title and it's part of your trust, and you just put it in your safety deposit box, will it just be dispersed by your trust or your will or whatever you had? So let's say that it's a Honda Civic, let's just say, and you've signed it, and in your will you put my 2020 Honda Civic to my cousin Steve. Yes, your executor would go grab that title, bring it to Steve, tell Steve, hey, the car's in the garage, here's the keys. Yeah, no probate required, automatic. One of the big, oh, you had 2 questions though.
Well, I was going to say, what if you're just splitting all of your assets between your 2 children equally?
What if you're splitting all of your assets and you've already signed this title? Great question. Whoever is the executor of your estate would be the one that would take charge of this, but it wouldn't have to go through probate. That person would list it for sale. For a Honda Civic, maybe you get $10,000 and you have 2 kids, they'd split it $5,000 each. But that title is already signed, so it can go to that new buyer. One question that I get a lot is, well, if we sign our title, isn't that an open title? Isn't that scary? Like someone could steal it? I'm not saying put your vehicle titles in your glove box, in your car. Keep it, we're in Montana, everyone's got a gun safe. Keep it in your gun safe, right? Keep it somewhere safe, but if you decide to sell it in a year, or 5 or 10 or 20, it's already signed. That law is not going to change back that it's going to suddenly require a notary. So if you decide to sell it, you've already got your signed title. So that is a really quick thing that everyone can do to avoid probate on vehicle titles. This one is really commonly missed by high dollar estate attorneys. We've seen really expensive, nice vehicles have to go through probate, even though someone had a nice trust. Really makes that trust meaningless, okay? Someone said my voice is raspy, so. Thanks, Alicia. Question. The question, I'll have you speak it to the microphone. That way everyone can hear, and anyone that might hear this at a later date can hear.
have some of our titles that list both of us, and or. Do we need both signatures on that title in that case, or would one suffice?
Good question. So if two names are on a vehicle title, do we need two signatures or just one if it's and or? You need them both. Just both sign it. But make sure to sign it exactly as it's written. Okay? Yep, the DMV is very, very, very picky on that.
Single signature, and I sign it, then we don't have to go about trying to ascribe that it's and or. It's just going to go to the other living spouse.
Great question. If there's only one on the title, then what do we do? Because we only need to sign one. Yes, just sign the one, and then make sure in your will or your trust that you say who you wanted that vehicle to go to or all of your assets. So yeah, it can go automatically to that other spouse. I get a lot of questions on, well, my husband's the only one on that vehicle. Is that a problem? Should we both be on it? No, that's okay if one spouse is on it. If your will or your trust says everything goes to my spouse, that's okay. It's not a problem. Also, and I'm a little bit extreme on this one, I think, but if you have a trust, that's okay if your vehicles are not owned by your trust. It is such a pain to go to the DMV and get the trust as the owner on all of your vehicles and get them re-registered. So I wouldn't suggest, and I don't ever suggest that my clients, after they set up a nice trust, that they go retitle their vehicles, re-register them, get new license plates in the name of the trust. Not necessary. Just sign those vehicle titles so that they avoid probate. They don't ever need to go into being titled by the trust. Just the act of signing them will avoid probate. Any other questions on vehicle titles? The second one, oh yes, one more back there.
I don't even know, do boats need titles?
Do boats have vehicle titles? Yes, most boats do, and their trailers do. So if you have a boat, a lot of time you have two titles. They both need to be signed.
Okay, what if, say, you forget to do a trailer or whatever, and now it has to go to probate for your children to have? What if the kids just say, you know what, forget it, have it? Do you have to go through probate?
What a good question. The question was, what if you forget a title, like a trailer title or a vehicle title? Does it have to go through probate? If it's not very valuable, like under $75,000, you don't need to go through probate. You can fill out an affidavit of death and submit it with the DMV. It's a couple of documents to do that and takes a little bit of time, but it's not bad. The DMV also has an automatic transfer on death paperwork that you can do, but I think that is basically more paperwork, time, and steps than just signing your vehicle title. So if you do forget one or two of them, it's not the end of the world, and don't think that if you can't find one when you're doing your estate planning that will trigger a probate. I'm just saying this is an easy step to avoid probate if they add up and add up to a significant amount, over $75,000 on your vehicles. The next is your accounts. I'm not talking about accounts like credit cards where you owe money, but what I am talking about is all bank accounts and all investment accounts. This is the big one. And before I get started on how to set these up as POD, I'll also say that if there's less than $100,000 in your bank account and you pass away and all of your assets total less than $100,000, your kids can fill out an affidavit of death saying, hey, there wasn't much money in their estate, so we don't need a probate, and the bank should just give the money over. Okay, that happens. Question.
Okay, when you said your assets, if something triggers probate, does it then look at everything that isn't on a trust or signed off on, or does it look at all of your assets?
Great question. If a probate is triggered, are all of your assets looked at through the probate? Is that right? Creditors have the opportunity to attack all of your assets in probate, yes, even if some of them were already planned for automatic transfers. So we want to avoid probate as much as we possibly can. And even if you have less than $100,000 in assets, make sure to set up your pay on death beneficiaries on all of your accounts, okay? Pay on death beneficiaries. And this is one, I'm gonna go real slow on this one because I see a lot of your writing. Every bank and financial institution and investment company has a designation for beneficiaries. And some of them call them TOD, transfer on death. Some of them are called POD, pay on death. And some of them are just called beneficiaries. But make sure to set up your beneficiaries on your accounts. When you pass away, your kids or your heirs can bring a death certificate to the bank and take the money out right away. It's a really quick process. I also want to say that in some cases, banks will say, whoa, 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 hang on. Your parents died, let's set up an estate account for you. Okay, that happens. Please don't do that. Don't set up an estate account. Just say, no, we'll take the money. Banks and financial institutions sometimes don't want you to have the money that they've been using and investing. And so they may drag their feet on giving you the money, but they ultimately need to. I saw a question back there.
Have a paid on death beneficiary, can a creditor attack that person's benefit?
Good question. The question was, if you have a pay on death beneficiary, but you also have creditors when you pass away, can the creditors come and attack the pay on death beneficiary's benefit, right?
Yeah, I wanted to know if they could attack the beneficiary's money.
Okay, so I'll give a couple of different examples here to answer that question. Yes, they can. Creditors have the authority, if they're owed money, to open up a probate for anyone that passes away. So any of your creditors have the right, the legal right to open up a probate and become the executor under your property if they wanted to. Now, if you had $5,000 or $10,000, $15,000 in credit card debt, and let's say you had $200,000 in a bank account, the credit card company would not open up a probate. They wouldn't. They'd just say, $15,000, that's all right, we're not gonna get it, who cares? Because it's gonna take them so much time and money to open up the probate, they just won't do it. So that type of creditor probably wouldn't open up a probate. Now, if it's $50,000 to $60,000 to $70,000 in credit card debt and you pass away and you set up pay on death beneficiaries for your kids, that credit card company could open up a probate to get that money back. So they're not entirely safe from creditors, but it is generally safe for avoiding probate for the everyday person.
Brent, what I meant is if I leave like my nephew money and he has creditors, can the creditors go after him?
Oh, sorry. I answered the question completely wrong, or different, not wrong. The question was that beneficiary, can his creditors go after the money that were left for him? Yes, they can once they're in his possession. Once the money's in his possession, the creditors can go after his money. The question was, well, how do they even become aware that he has money all of a sudden? They can track bank account balances of his, and they can track his balances, and they can disgorge his money. They can lien his real estate. They can do a lot of things to get money from him. Anyone else have any more questions on accounts? Yeah.
So if I had passed and I had a whole bunch of debt and my kids took the money out of. So if I had a bunch of money and I passed away and there was creditors coming after my money, but the kids have already taken out the money, do the creditors still have the ability to go after that?
The creditors, the question is do creditors have the ability to go after your kids if you have high debt to creditors, and you did POD beneficiaries? They can, technically.
Even if they took it all out?
Yes, even if they took it out, they can technically go after them. Do we see that very often? No, we don't. And generally, kids are somewhat aware of their parents' debts if they're high debts. Yeah. And a lot of times a creditor like that would attach to the real estate sooner than allowing some bill to get pretty high. And so being attached to the real estate, it's pretty easy to deal with for kids because they can sell the real estate and then it's paid off at closing.
Okay, so you have your real estate under a homestead, which protects the creditors, you from creditors. Now, if you die and you still have that homestead, can the creditors attach if you have a beneficiary or transfer of death along with the homestead?
So the question is if you've filed a declaration of homestead on your real estate to protect you from a certain amount of creditors, and you have creditors when you pass away, how would they get paid? Or how would you be protected from those?
Well, no, and you have a beneficiary deed along with the homestead. Can the creditors attach to that beneficiary deed with the homestead?
Your homestead declaration won't protect you from all creditors. That's a little bit of an overstatement on homestead declarations, but let's say one of your creditors is a mortgage lender. They have a secured interest in the real estate, and so let's say you still owe $100,000 on your house when you pass away. The title does transfer to your transfer on death beneficiaries, which is great. They'll own it subject to that $100,000 secured claim. So they can either refinance and get their own loan and pay off that $100,000 and get their own loan, and that creditor gets paid in that circumstance, or they can sell the real estate and then that creditor gets paid their $100,000 at closing. Yes?
On accounts, bank accounts, investment accounts. If you earn them or have them from another state, is that play into this at all? And do you need to put it in your trust versus pay on death?
Great question. If you have bank accounts or investment accounts in another state, do you need to put them into your trust versus pay on death? Make the trust the owner of those accounts or pay on death. I would actually be okay with either. So if the trust is the owner of those accounts and you pass away, the trust didn't pass away, so there's no probate. So that's great. It's a good thing about trust. If you've set up pay on death beneficiaries, like maybe your kids, that would be okay too. They would get an automatic transfer to them. You can also set up the trust as the pay on death beneficiary as well. So any of those three things would be fine. To me, sometimes it takes a lot to open up a new account under the name of your trust. And then everyone wants proof, certifications, all this stuff. So to me, sometimes it's just simpler to just do a pay on death beneficiary designation to your trust. Not everyone wants to get a whole new checkbook with the trust of, right? And I just don't think it's necessary. Real estate, the third of the TARs. real estate either needs to be held by your trust. So you move here and you set up a trust, the trust needs to be the owner of your real estate. And a lot of people will think, well, the trust is mentioned here in the real estate, my address is mentioned in my trust, it says it owns it. Your record title deed needs to show that the trust is the owner, okay? So whoever you see on GIS or Onyx maps and whoever has your warranty deed, that needs to be the trust if you have set up a trust for the trust to be funded. It doesn't matter how great your trust is if you have this nice big trust, but you're the owner of your real estate. That doesn't avoid probate for you. If you are a non-trust person, then the way to avoid probate is what's called a transfer on death beneficiary deed. Montana has these. They're absolutely wonderful. You name your kids or any other heirs or beneficiaries you want as the transfer on death beneficiaries. Usually we have 4 or less on those. And when you pass away, your kids automatically inherit your real estate. It works out pretty well. One of my favorite things about transfer on death beneficiary deeds is that the heirs have no power or control. So I always tell people, you could rent out your house, you could burn it down, you could sell it. Your kids have no power over you or your real estate. You can revoke it at any time, you can change it at any time, and it avoids probate. So if someone was to sign their vehicle titles, make sure that their kids are all pay on death beneficiaries on their accounts, and do a transfer on death beneficiary deed, they would avoid probate entirely. Okay, real straightforward. Not everyone's circumstances are the same though. Sometimes there's complex family dynamics. Sometimes they own out-of-state real estate. So in those cases, I'd be like, no, transfer on death deed doesn't make sense for you. You own property in California. Let's put them both in the trust. So to summarize, on the most important slide, these are the probate assets. These are the ones that have to be planned for, no matter what your estate plan is, whether it's a trust or a will. And those first 2 are ones that pretty much everyone can do. Every account has the ability to be a pay on death, transfer on death, or beneficiary designation. Titled vehicles, anyone that has them, sign them exactly as written. As far as real estate, if you have a trust, you probably should hire a realtor or a lawyer to do the grant deed to the trust, that the trust is the owner, or a lawyer for the transfer on death beneficiary deed. Those aren't ones that I would typically recommend people do by themselves. Does anyone have any more questions on the probate assets? Yes.
How does transferring your real estate title to trust affect insurance?
Good question. How does transferring your real estate from yourself or you and your spouse to your trust, how does that affect your insurance? Doesn't affect it. Won't affect it at all. You guys are still the owners of your trust. And another question that's come up recently with this, Montana has this new homestead tax thing. Everyone's probably heard of that. If you transfer your real estate from yourselves owning it to your trust, that still applies. You still get that homestead exemption, which is nice, a reduced tax rate. So doesn't affect it.
Excuse me.
Oh, yes.
If you don't have a will or a trust of your own, however, you have one heir and they have a trust, how about putting your real estate and vehicles in their trust?
Great question. Great question. So the question on the table is, if you don't have your own estate planning, will or trust, but your kid does and they have their own trust, should you just transfer your stuff into their trust? Your assets, your real estate accounts, vehicles. You should not. Your kids or your heirs will receive a step up in tax basis if they inherit both accounts and real estate. But if it's transferred to them during your life, they will not receive that step up in basis, so they'll get carryover basis. We'll go over that in a little bit too, more in depth, but you'll also lose control of your assets. So if it's your house that you're putting in your kid's trust, that's no longer your house. That's a trust that's managed and owned by your kid. So they could kick you out, they could sell it, they could do whatever they want. It's not yours anymore. If you want to cash some money out and go on a long vacation or go live in a nice retirement home, you can't choose to do that any longer because you no longer own that asset. They might say, no, that's too expensive. That's my inheritance, right? I've heard it, yeah. Yes. Oh, an automatic transfer for real estate, what would a lawyer charge? So for a transfer on death beneficiary deed, typically it'd be like a half hour of work, probably like 150, 200 bucks, somewhere in there. There is a $40 recording fee that the county charges as well. So that would be about the range if someone was like, hey, I just need a transfer on death beneficiary deed. That's what it would be. Any other questions on the most important slide? Power of attorney forms. All estate plans come with these. These only apply during your life, and they're actually really important. When someone sees a big book of estate plan stuff, some of it may be the trust, some of it may be a will, but the rest of it is power of attorney forms. And they sound confusing, but today I'm going to make them real simple. One of them is always called a financial power of attorney. It's also known as a general or durable power of attorney. It allows someone to act on your behalf for financial matters during your life. Financial power of attorney allows someone to act on your behalf in your best interest during your life. Usually it's the same person that you named as your executor because it's someone you trust, or usually it's your spouse. But really useful to have that in case you get hurt on the ski mountain or something and you need bills paid, the financial power of attorney can step in and do that. And again, they can only do that in your best interest, not their own. The next power of attorney is the medical power of attorney. The state of Montana actually wrote this form, so that the legislature wrote it, and it spends about 4 pages saying that your power of attorney agent can't use your information and go sell it off to pharmaceuticals. They can only use it to talk to your doctors, pick up medications for you, ask that you're moved to a different care facility. But really, a lot of that document and a lot of the medical power of attorney is for privacy and secrecy of healthcare information, which is private. So the medical power of attorney typically is the same person as your financial, sometimes different. Question, Alicia.
Okay, mine's kind of a confusing question. Recently, I have been asked by some very dear friends if I would be their medical directive or their medical power of attorney. That is not in writing because they have a child that lives on the East Coast. This would be in the event that something happened to them and I'm the closest to them. And so my husband and I agreed because they really trust us with all of their medical issues. My question is, do I need to send them back to you? They are clients of yours. Do I need to send them back to you and have them put my husband and I on their document as their medical power of attorney in addition to a child who lives on the East Coast?
Really good question. So a medical professional that's here with us, it's Alicia. She's the medical and health director here at Crossroads. The question is if she has a friend that said, hey, we really want to make you our medical power of attorney. Our daughter lives on the East Coast. What do we do? How do we do that? So the first answer is that the verbal, I want this, that doesn't go very far. So a doctor won't listen to Alicia if she said, they wanted me to be power of attorney. Won't go very far, doesn't work. The second answer to your question is yes, they need to have their medical power of attorney redone. And what they should do is have someone that's close, local, that they trust, you, as first maybe their spouse, so their husband or wife first, and then Alicia maybe second, and then third, they can have their kid on the East Coast. So if their spouse is unwilling or unable to be the power of attorney agent to talk to their doctors, then you can. If you're not around, then the daughter can. So sort of everyone's still there and able to help.
Okay. I did tell them that obviously if one was incapable of making the decision, they're both in declining health. And I said, we would be happy to do that, but I believe that that's a legal document that you're asking me to change, and I just cannot step in and make a decision for you when your when your child already has the authority to make that decision. So I was correct in saying they need to come back and see you.
Yes.
Okay.
They need to change their medical power of attorney to have the exact in line of how they would like that to go. Yep. Great question. Connie?
Can these people put two people as their first person that they consult each other?
They can. The question was, can you make co-medical power of attorneys? You can. I'm not as against that as I am for co-executors or co-trustees or co-personal representatives. But for a medical power of attorney, say you have two kids, you can say either or of these can make this decision. Yeah, you can do that. And I'm not really against that. Typically, I like to have a clean chain of command with who will make the decisions. Sometimes you get a little bit of paralysis by analysis when you've got multiple people, too many cooks in the kitchen.
You did say either or, but I was thinking more like, they would consult if one's on the East Coast and one's here.
Yeah. So the question is can the person signing the power of attorney, granting the power of attorney to their kids, can they make it be a consulting thing where either kid has to consult with the other one? Not really. And the hospital isn't really going to sit there and look and be like, wait, did you consult with your sister? What they're looking for is they're looking for who has the power to talk to them and make these decisions, and they need to be pretty snappy. So power of attorneys, medical and financial, they're a pretty quick thing that you need right away on the spot. The last one is called a living will, and it sounds like a last will and testament. It sounds like a thing that distributes property, but a living will is not. A living will is actually a pull the plug order or a DNR, okay? These have become increasingly important because when someone's laying on their deathbed and there's no chance that they're coming back, it's really good if they have a living will in place that their doctors or whatever medical facility they have, that they can at least look at that and say, hey, they listed this person as their agent to say when it's time to go. Okay, that is this one. And a lot of your doctors and other medical professionals have one of these as well. There's nothing special to them, but the important thing is some people may not want to be laying there brain dead for 5 or 10 days. They may want to be let go. And whoever you put as your living will agent typically is the same as your medical power of attorney. Someone that you trust to be like, okay, it's time, let's stop the oxygen, so to speak. And I mentioned this a little bit, but every estate plan, wherever you go, they will have these 3 power of attorney documents in there as well. Tax considerations. Oh yeah, question. There you go. I think,
Is that just a person, or is it a document that describes under what conditions you don't want something to be, you don't want to be resuscitated?
yeah, okay, so the question is the living will,
Now, and I'll preface it with, I actually had a doctor argue with me about the degrees of all of this, about wanting exact types of descriptions of how you didn't, why you didn't want resuscitated.
okay, so the question on the table is this gentleman had a miserable experience essentially arguing with a doctor over a living will. And does the living will just name the person, or does it specify exactly what situations this person would want to be disconnected from life support? There's actually, so your living will does name that person, gives that person the authority to talk to doctors in end of life decisions. And sometimes that means arguing with the doctors. Usually it doesn't. But there are two different types of living wills. One of them has specifics. There's actually a really good episode on Seinfeld about it where Kramer gets a living will and he's going through and he's like, I can't be on a feeding tube because I have to be eating at the coffee shop. So there are ones that are very specific. Generally, we like to use one that says, if I'm not coming back, if I'm in a vegetative state, please pull the plug. That's generally what we find is best. Now, doctors have their own moral and ethical guidelines when it comes to end-of-life care. And so they have the ultimate control in that room, but the power of attorney at least gives that your agent the ability to talk to them because they won't talk to them without it.
This was initiated by a local hospital here. It wasn't the doctor's personal opinion. So that's
In this situation, it was a local hospital institution that this happened at.
yeah.
Okay. All right.
He was an employee of the hospital at that point.
And if that were to happen to someone, I would recommend they have that living will in hand and ask to talk to the attending physician right away. They typically are the captain of the ship in that situation. And I really wouldn't talk to anyone else on it, any other medical staff. Question.
Should the living will include a physician's order for life-sustaining treatment, the pulse forms?
Yeah, should the living will have the pulse form? Yeah, it should. Yes. And a lot of your doctors may even ask if you have one of those forms, and the hospitals have their own as well. It's called a pulsed form. I'm not sure what that stands for, but essentially your living will, and Alicia might know, she's our medical professional here.
Stands for Physician's Order for Life-Sustaining Treatment. And basically you fill it out and it's a column of if I'm this way, then I want this done. If I'm unconscious, then I want this done. If I'm near death, then and you just check the boxes. It's very easy. It's easy to work through. It's just like maybe 10 questions. And it's very easy for the family to take a look at it, and that way there's no question. And there's no reason why you would have to give as to why you wanted your plug pulled.
Exactly. And actually a lot of your doctors, if you ask them, do you have a pulsed form that I could fill out? They have those. From the law office perspective, we have a general living will that says, hey, if I'm not coming back, this is the person I want talking to the doctors and making decisions. Yes.
And I guess these three forms you should give to your executor. And if you executor at some point, I guess you just have to ask for them back, or.
So the question is these three forms, the financial power of attorney, medical power of attorney, and living wills should you give those to those agents, those power of attorney people? Yes, you should. Yes. And if you change it, you should tell them. Yeah, that would be a good idea. But whoever those agents are, they should have them. As far as other estate planning documents, like your will and trust, I typically don't recommend you share those with the beneficiaries, for sure. It's really none of their business. No one is entitled to anything. This is your estate plan. They should know that it's in the gun safe or wherever it is. But so many fights happen based from kids just being upset at their parents' current estate plan, and it's pretty disrespectful. So, I'm going to move on to tax considerations, which is my favorite. Montana doesn't have death tax, which is great. So long as we have all of our probate assets planned for, there's no death tax here. Inheritance tax, Montana doesn't have it either. So those are things we don't need to worry about. Capital gains. This is a really interesting part of estate planning. And I see a question over there. Yeah.
Does the federal government have a death tax?
Great question. Yeah. Does the federal government have tax? It does. That is called federal estate taxes. And currently, if someone has $15 million or more, or if it's a couple, $30 million, then they are subject to federal estate taxes. If you have less, if you're married and you have less than $30 million, you do not have federal estate tax exposure. You won't be taxed. Okay? I want to talk about capital gains and how they work with real estate. And I'm going to use some sort of crude, simple examples. So let's say you purchased your real estate for $100,000, and let's say you sell it for $1 million. Okay, you now have $900,000 in capital gains. There's a exception amount of, I think it's around $400,000 or $500,000 that you don't have to pay, but you have $900,000 in capital gains. Now, you will be taxed on that at a pretty high rate. If you give your real estate, so that's if you own real estate that you bought for $100,000 and sold it for $1,900,000 in capital gains. That's basically how capital gains works. If you bought your real estate for $100,000 and you decide, I want to give it to my kids, and you give it to them, and it is now worth $1 million, but you give it to them while you're still alive, they receive it at a tax basis of $100,000. So they get your same tax basis that you had. That's called carryover tax basis. So if you're gifting family real estate, they get carryover tax basis during your life. And so if they decide to sell it for $1 million, they now have a $900,000 capital gain. So they owe a lot of taxes on it. Additionally, if you were to give your family real estate, you'd lose control over your real estate. You wouldn't be able to refinance. You wouldn't be able to take a loan. You wouldn't be able to sell it, rent it out, do whatever you want with it. You lose control over your real estate. Now, inheriting property in Montana is a really good thing because everyone gets what's called a step up in tax basis. And I'm going to take a minute on this one because I just want to be really clear on how it works. So if a client asks, hey, should I give my kids my real estate now, or would it be better if they inherited it? It's way better if they inherit it. If that same situation, the person bought their property for $100,000 and it's now worth $1 million, and they pass away and their kid inherits it, their kid gets a tax basis of $1 million, the date of death of the person, okay? So they get what's called a step up in tax basis. So if their kid sells it for $1 million, what it's worth, they will have $0 in capital gains. All that capital gain goes away. So in Montana, it's way better to inherit real estate. Now, trusts allow for step up in tax basis, and transfer on death beneficiary deeds also allow for a step up in tax basis. So from a tax planning perspective, inheriting property is much better than being gifted property during your life. There are a couple different exceptions or times where it might make sense, like maybe you have one kid and it's a family cabin that they'll never, ever, ever sell. Well, that means they're never going to see those capital gains tax because they're never going to sell it. So it wouldn't be the end of the world if they owned that family cabin. That can happen. Always consult your CPA on these questions. I'm not a CPA. So just general basic estate planning advice here. You had a question? Good question. So if somebody passes away and their kid inherits their property, and then a couple years later that kid dies, do they keep getting step up in tax basis? They do. Yes, to the value at the date of death of the owner. Yes, they do. Yep. Question over here.
What about stocks?
Stocks. Great question. Yes, stocks do get a step up in basis. There are some tax advantaged accounts, IRAs, where the decedent already got a tax advantage early on that the financial advisor and your CPA would say, okay, you're actually going to owe this amount on taxes because you inherited this stock because that was a tax advantage account. That's a pretty nuanced thing, but generally there wouldn't be any tax except on those accounts on which the decedent already had tax advantages on earlier. So they had already gained that advantage.
If you didn't transfer your property prior to passing, and the property goes through probate, you still get the step-up basis, correct?
If you, what was the question?
If your property goes through if your property goes through probate, you still get the step-up balance?
Yeah. If you didn't do a transfer on death deed, you didn't do a trust, do you still get a step up in tax basis? Yes, you do. Yes, you don't get carryover basis. It's still stepped up. Yes, you're still inheriting it.
Okay. Just for tax advantage investment accounts, are Roth and IRAs treated differently? In this case, are Roths basically exempt from tax implications?
It's my understanding that they are treated differently and that Roths, the decedent wouldn't have gotten those tax advantages early on, and so those wouldn't be taxed, but a traditional may. But that's one that I would have you talk to your CPA on that one. Yeah, I won't claim to be an expert on that. Any more questions on tax? Yes. Okay. One more.
So if one has money invested into an HSA account, I'm not sure what the age is, but at a certain point, it's like 62, 67, something like that. It can then be spent on whatever without it being taxed. But the money that's put into that, if one kicks the bucket once they have a bunch of money dumped into it, and they're beyond that point, beyond the point of being taxed, can that transfer over to the inheritor, whoever is to inherit that? But what if they're no longer, or if they're before that age where it can no longer be taxed?
So the question is there's an HSA account with a time frame on which the person that has the account would not be taxed on those dollars until a certain age. And then if that person was to pass away, would their beneficiary be able to have those same opportunities or benefits even though they may be under that age? Is that right? I don't know. Yeah, that is really a question for a CPA. Yeah, I don't know that one. Sorry. Yeah, I will look it up though, because that's an interesting question. Yeah. Medicaid planning. Who has heard war stories or terrible stories about Medicaid stealing all their family stuff? It's not actually true, but we hear a lot about it. And a lot of my clients come in and they say, hey, I just don't want Medicaid to steal everything that we possibly have. What's the deal here? How do we avoid it? There's a couple of ways, but first I want to talk about Medicaid, what it is, and just want to talk about some pros and cons of potential planning around it. Okay. Medicaid is state-funded help for those who need it. It's not Medicare where everyone gets it. Medicaid is state-funded help for those who can't afford care. That's what Medicaid is. And so you have to apply for Medicaid, and when you apply, Medicaid says, hey, you don't have any assets? Yes, the state will take over your care and will pay for it. Or Medicaid says, no, you have way too many assets. You can't apply for this. We're not going to accept it. And so what some people will do is they'll say, well, hey, let me just bankrupt myself, give everything I have to my family right now, and then I can apply for Medicaid, and Medicaid will think that I don't have money. This will be great. So Medicaid was like, oh, people are cheating us, so they imposed a 5-year look-back period on all such transfers. So if you give your bank accounts and your real estate, your vehicles to your kids, and then you apply for Medicaid, Medicaid will consider those fraudulent transactions, okay? And you will not be able to receive care from Medicaid, and you will not have assets, okay? So people started doing that. And one thing that can be done is if you're relatively healthy and you think you're gonna be healthy for at least 5 more years, you can do that. But your kids are gonna get carryover basis on your real estate, and they're not going to get those tax advantages, and you're going to lose all control over your assets. So I generally don't recommend that people do that type of Medicaid planning. The other thing people can do is what's called an irrevocable trust, where they get to live in their house for the rest of their life, but they no longer have control over it. So if they don't have control over it, that means creditors can't attack it, including Medicaid. And so if they don't technically own that asset because their irrevocable trust now owns it, well, that means that Medicaid can't say, oh, you own this house, because they don't own it. Again, they're losing control over that asset, so generally not something that I recommend, but some people will do it. The control ends up being really important later in life, and sometimes there's this push and pull between parents and their kids. Their kids many times are trying to preserve assets for their own inheritance. I happen to think that's really inappropriate and unfair. And the parents are sometimes trying to preserve assets to leave to their kids, but sometimes they're looking at, well, how can I get the best care possible for my last years in life? So irrevocable trusts are an option. They are still subject to the 5-year look-back period. Giving away your assets to your family during your life is an option, still subject to the 5-year look-back period, and your kids will miss out on the benefits of inheriting property. Any questions on Medicaid? Guardianship and conservatorship. What is a guardian and conservator? It's actually a heightened level of power of attorney. So a power of attorney can act on someone else's behalf during their life. A guardian and conservator can act as them during their life. And guardian and conservators, we name them in our wills if we have young children, that our children would have a guardian and conservator that can sign parent consent forms, that type of thing. Also, when people become incompetent or infirm, they can't make their own decisions any longer, a power of attorney may not work. Let's say, let's say that John is 80 years old and his dad, Dave, is 100 years old, okay? And Dave is making questionable financial decisions and buying a lot of stuff online, okay? John has financial power of attorney over Dave, which is great. He can help him out, but he can't stop these transfers. Dave keeps making all these purchases. So John might apply to a court for guardianship and conservatorship to be able to shut Dave off from all purchases online, to protect his money, to protect him from being scammed, that kind of thing. So thing to remember about a guardian and conservator, young kids or for someone that's infirm, and it's a stronger level than a power of attorney. It's actually court appointed. And in order to get a guardian and conservator, a court visitor needs to be appointed. The protected person needs their own attorney, actually, and they need a doctor's report saying that this person needs this type of extra care, that a power of attorney won't work. Is there a way to make this process smoother? We always put it in our estate plans, who becomes the guardian and conservator if the power of attorney isn't enough. And usually it's that same agent. But if that's not written anywhere, it makes it a lot harder for the court to make that decision to remove that person's rights. Now, I want to open it up to any questions and anything that maybe someone wanted a few more answers on. Yes?
So for the 5-year look-back period for Medicaid, is it correct that if it's in an irrevocable trust, that Medicaid won't take that as an asset, but if it's in a revocable trust, they will?
Yes. So the question is, in terms of Medicaid planning, if it's a revocable trust versus irrevocable trust, what can Medicaid go after? Let's say that you've gone past the 5-year look-back period and you had already put it into an irrevocable trust. Now Medicaid can't go after it because you don't have control over it, so your creditors can't go after it, and it's beat the 5-year look-back period. But if it's in a revocable trust, then Medicaid can go after it because it's still your asset. So it hasn't even started the clock on the 5-year look-back period. Yep, great question. Yes?
You're allowed to provide, like, what is it, $17,000 to a child, tax-free for the year. So I could give $17,000 to my son, $17,000 to my daughter-in-law. My wife could give $17,000 and $17,000. Is that still part of that 5-year look-back?
You can do that. Consult with your CPA on that. But yes, you're essentially talking about spending down your estate to have less money to show Medicaid if you were applying for Medicaid. Yes, you can do that.
So I live in Montana right now. I create my estate plan based on that fact. And then 20 years from now, I move to Iowa, for example. Do I have to start over again?
Great question. So if you have your estate plan in Montana, you live here, and in 20 years you live in some other state, will you have to recreate your whole estate plan? Probably not. but it depends. And I hate when lawyers say it depends because they always say it. But it's going to depend on your probate assets, where they are. So if you buy a new house in Iowa and you have a trust, then just make sure you buy the house in the name of your trust. That's it. You won't have to redo your estate plan. Your power of attorney documents, those are only really accepted by banks and hospitals for 20 years. So with your example, if you move in 20 years, you probably should get updated power of attorney documents. But other than that, you know, my practice, I can't speak for all lawyers, but I don't want my clients to have to keep coming back to me every couple of years to update their estate documents. I don't want that. I want, when you leave, that you have a clean product that avoids probate, and it's not something that you're gonna have to worry about down in the future. You know, we do call, Dorothy Vanna White here calls all my clients every 5 years to make sure that they're still happy with their estate plan, make sure nothing changed. But we typically don't want constant revolving door of clients. How lawyers used to draft estate planning documents is they used to draft them so that they would be the ones that do the probate. So it was this money machine, right? So we do the will, and then in 20, 30 years, we do the probate, right? I really don't think that that's the right thing to do. I think let's just do the estate planning with the idea to avoid probate. And we do a lot of probate work, but I think that that's actually made me the most improved of the estate planning, because I see how all these probates were triggered. We can talk about accounts, vehicles, real estate, all that stuff, because that's what triggered them in the probates that I do. And I'm like, man, I wish these guys would have just gone over to Glacier Bank and set up their beneficiaries. It would have saved so much money and time. Back there.
Does your real estate or home have to be paid for in order to put it in an irrevocable trust?
Great question. Does your real estate need to be paid for before you put it in an irrevocable trust? No. And not a transfer on death deed or a revocable trust. And a lot of my clients will come in and say, well, I don't own my house, the bank owns it. That's not really true. You do own your house. The bank owns a secured interest in it. So you can do whatever you want with it. You can sell it, you can rent it out, you can put it in an irrevocable trust. You can do these things. The bank's still gonna have that secured interest, and that's okay.
I have a question. You mentioned earlier that probate could be like 10, as an example, 10 to 15 legal documents, running $3,000 to $10,000. Are they just going to be documents that are like the accounts, the real estate, and the titled accounts, or are they going to be other documents that you could tell us about?
I guess the best answer is I'll just tell you what they all are. What are the probate documents? It's an application for probate. It's a fiduciary statement saying that the personal representative isn't going to make anyone screwed over, okay? It's letters testamentary, giving the executor the ability to act. And so the bank needs to see the letters testamentary. They may need to see the application. It's a notice to creditors. It's a notice to all heirs. It is an inventory of everything in the estate. It's an accounting of everything in the estate. And it's a PR's or personal representative or executor's sworn statement to close the estate. Those are the general probate documents, but based on what needs to happen, sometimes real estate needs to be transferred, so there will be a personal representative's deed of distribution, that type of thing. Sometimes heirs agree on that one of them will take the real estate and the other one will take cash. And so in some cases we have estate settlement agreements, but those are the general probate documents. It's just the court requires all of them. So it becomes a lot in legal documents, so it's just kind of expensive.
And what would you say it takes time-wise to do that, if you had everything kind of lined up?
So time-wise, that's, so if lawyers bill at $300 to $325 an hour, and let's say it cost, what would be an easy
I just mean like
thing?
time-wise. You know, just-
Time period. Yeah, notice to creditors are required to be for 4 months. So creditors have 4 months to attack an estate and probate. And so if you have credit card companies, that kind of thing, they can make a claim for 4 months after the probate has been entered. So a probate can be open anywhere from 4 months to sometimes 2 years, just depending on what needs to happen. Some of you are like, 2 years, what? How is that possible? Sometimes a probate has an asset like real estate that just needs to sell, and it just hasn't sold yet. And so everyone's just waiting for this real estate to sell before the creditors can get paid and the heirs get their checks.
I have one more question.
Yeah.
Did I hear someplace before that, like with Medicare, if the person goes into assisted living, not Medicaid, but Medicare, that they could attach to the assets, like the real estate or whatever?
Medicare won't, but Medicaid can, yes. Yeah. So if you do need Medicaid and you still happen to own real estate and you apply for Medicaid and you're accepted, Medicaid can attach a lien to your real estate to get paid back. Yes, that can happen. Question.
If you choose an executor who is in a completely different state, many, many miles away, what kind of problems come from that?
Good question. If you choose an executor that's many miles away in a different state, what kind of problems come from that? If you would have asked me that 10 years ago, I would have said, no, you should probably pick someone local, because having court documents and signing, it's all kind of a pain if they're not local. In today's world after COVID, we're using DocuSign for as much stuff as we can, and video calls, video chats, all of that stuff really doesn't matter too much how far away the executor is for most things. Now, if there's a big barn that needs to be cleaned out and the executor is the only person that can do it, you know, sometimes that creates problems, but generally your executor, you want it to be someone on earth that you trust at the highest level. And if they're a few hundred or 1,000 miles away, that's okay. Question back there.
It has to do with accounts and beneficiaries. If you and your spouse are both on the account and you have beneficiaries listed, but just one spouse passes on, does it first go to the other spouse on the account and then upon their death go to beneficiaries, or does that become an issue at all? Should they be
Great
the
question.
beneficiary?
The question is if you have an account with your spouse as joint owners and you have beneficiaries set up, if one of you passes away, is there a problem like a fight or a dispute between the beneficiaries? No, it goes straight to your husband first, or you. So husband, wife, joint goes first, and then beneficiaries second. You're set up perfectly if that's how you have it set up. And that's exactly how I'd recommend you do it. Yeah, that's great.
And I had a question. We own a small business in the form of an LLC, which doesn't fit into your TAR categories. How would we manage that transferring on for someone to liquidate or continue?
Yeah, LLC is small business. There's a one-page sheet called an assignment of shares. And what I would recommend is you put it in your estate plan that says, and it's a little bit more specific than this, but essentially identifying your LLC, who the members and the owners are, and that when you pass, those shares would pass to your kids or your spouse or whoever you wanted it to pass to. And that can avoid probate, because when you pass away, the LLC doesn't pass away. Yeah. In some cases, like I have a law office, I'm really not gonna, my wife's not gonna go to law school all of a sudden and run a law office, so that business would dissolve likely. So, question.
I have an elderly mother in England, a brother in Florida who's the executor, who is not physically capable of going to England, and he has said that he will sign over that executor status to me. So if she's in a hospital in England, how quickly can that happen?
Okay. Does mom have assets in the United States? No. Okay. So the real answer, the question is mom's in England, brother's in Florida, and you're here, and brother doesn't want to be executor, and mom, if she gets sick and needs a new executor, what would happen? How long would that process take? Well, the first answer is I don't think that mom has probate assets. So I don't think there's going to be a probate. So, oh, and she has assets in England? Oh, I don't know England law. Yeah, so the question
in order for
is
me to assist her.
yeah, if you need to be the executor in England, right? If she passes away there, you need to hire a lawyer in England to tell you that answer, because I don't know. It'd probably be one document that your brother would sign, assigning you as the executor. Probably be one document, 2 or 3 pages, notarized, maybe even an apostille. That would be my best guess. Probably would be pretty straightforward. Yep. Yeah.
Taxed for that?
The question is if you leave money to someone that lives in a different state, will they get taxed for that? It actually depends on that state's income tax laws. And really what you'd need to do is talk to your CPA and ask specifically for those states. A lot of states out east have inheritance taxes like that they will imply. Yeah. Anyone else with other questions? If you feel free, I got cards over there. If you want to just send me an email or give me a call. I'd be happy to answer if you feel like your questions weren't answered today.
So I also have a small business, but I'm sole proprietor of it. So because my business and my tax ID are basically the same, is there also a form that I could fill out to separately pass on and treat my business separate, or does it need to be like an LLC where it has separation of tax IDs?
So for a sole proprietor, I guess I would answer your question with another question is, does the business own probate assets? Because if it doesn't, then really you can just fill out a document or a sheet of paper that says, I want this company to go to my wife or kids or whoever you want it to go to. Because if it doesn't have probate assets, then the particulars on the planning aren't very particular. You can just write it down. Yeah. Most people spend more time spending time planning their vacation than basically working on their estate plan. And it's really not about the documents. It's just about making sure that you have a plan going forward. We talked about the TAR, right? Titled vehicles, accounts, and real estate. And good planning will reduce stress, avoid conflict, and make things dramatically easier for your family. You don't need a perfect plan, guys. So if this seminar made you motivated to take that first step, then it was worth it. So thank you guys so much for coming.